Good morning, everybody. Thank you so much for joining us today, Victoria. And this is a Victorian session, obviously, about water ingress and building defects claims. I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate, a body corporate management company based in Queensland. I'm your host for the webinar today, and we warmly welcome Phillip Leaman from Tisher Liner FC Law. Are you facing water ingress or building defect issues? If you are embroiled in a claim and just don't know where to start or how to progress, this webinar will assist you. Phillip is speaking about what to do when you're faced with water ingress claim, who is liable and who can be pursued for costs. And Phillip will also be providing practical information on the procedure for initiating a claim. While some of our state-specific sessions are applicable around Australia, we do stress that this session is based on Victoria's legislation and it's not applicable in other states. And before we begin, I'd like to mention that the information in this session, including the discussions arising from submitted questions and chat conversations, is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in today's session. We welcome Phillip Leaman from Tisher Liner FC Law. Phillip understands that most disputes involve lot owners who must live together after the dispute is over. He provides practical and strategic advice to owners corporations about defect claims and disputes between lot owners, contractors and managers, and also assists owners corporations in governance, interpreting plans of subdivisions, leasing and licensing, and adverse possession. He acts for owners corporations in Victoria and also ACT. So Tisher Liner contributes regularly to LookUpStrata content, and you will have seen articles from Phillip in the Victorian Strata magazine. And we welcome you today, Phillip, to the webinar, and it's really great that you've joined us. It's great to have you here.
Great, thanks, Nikki, and welcome everyone. Thanks for sharing your morning with us. Well, thanks everyone. Today I'll be talking about Water Act claims and building defects that specifically affect owners corporations in Victoria. A little bit about what I do and what our team does. We have a dedicated team at Tisher Liner that all they do is owners corporation work, including general advice, governance, interpretation of plans of subdivision, levy recovery, building defect and Water Act claims, and a whole range of other issues that affect owners corporations. So today we're going to talk about a couple of topics. So what does an owners corporation do when they're faced with an water ingress claim? So how do they grapple with it? What do they need to know? What investigations do they need to carry out? Who's liable for the claims, and can liability be passed on to others to reduce the financial burden to lot owners? What happens if the building's been constructed in the last 10 years, and can the builder or other parties be pursued? Presume under building statutory warranties or some other right of action against the third party. And how does the process of making a claim practically work? And what are the first initial steps that an owners corporation needs to take? So water damage to lot owners due to common property defects, who's liable? So normally if you're a manager, the first call you get is from a lot owner who says, hey, water's leaking through my ceiling and it's destroying my carpet and my plaster, and, come and sort it out. We've got to really start from, well, what's the current legislation that governs owners corporations? And we look at the Subdivision Act, the Owners Corporation Act, and the associated regulations that really work out the roles and responsibilities of lot owners versus owners corporations, and in relation to who's liable for what. So the first question is there a water leak? If there is a water leak, really the owners corporation needs to take those initial steps and work out, well, is there a water leak? Let's get an expert and have them inspect from where the water leak is coming and ascertain what the extent of the damage is. And we need to figure out, where is the leak coming from? Is it private lot property? Is it common property? Is it a mixture of the two? Or is it really unknown and further investigations are required? Quite often an owners corporation is called up by a lot owner, and the lot owner says, well, it's definitely coming from common property, and then investigations are taken. It's really from the upstairs balcony, from a defective waterproof membrane, for example. So it's really important to ascertain the exact source of the leak. And sometimes that can be very difficult, particularly with water ingress matters where water flows all around the place before it gets to the ultimate destination. So when we work out from the expert where we've pinpointed on the building where the water leak is occurring, we then need to have a look at the plan of subdivision to determine, well, what are the legal boundaries between common property and private lot property for the particular property? because unfortunately, all plans of subdivisions are prepared differently. Whilst there are guiding principles about plans of subdivision, every plan needs to be interpreted depending on the specific way the building has been constructed. So the first part of interpreting the legal boundaries is working out, well, what are the legal boundaries between private lot and common property? And there are four main types. We've got the interior face, a median, where we're talking about a floor or a ceiling, a median face for a wall, window, door, balustrade, or exterior face. And the plan of subdivision will set out which of these boundary types apply to which part of the building. And they'll say whether, all boundaries are interior face, for example. Some might be exterior if they're marked with an E, etc. So it can become quite complicated, and it really is, in my view, kind of beyond the role of a manager to have to work that out if it's not simple and straightforward, because a lot of liability can arise from getting it wrong or getting it right. So it's really important to get a surveyor or a lawyer to really provide an interpretation if you're not sure. There are plenty of managers out there that are very, very good at interpreting plans of subdivision, but if you're not and you're not sure, you really shouldn't guess. The subdivision regulations assist people in working out what are how do you actually work out what an interior, a median, or exterior face is relevant to the actual construction of the building? Because as we know, with a plan of subdivision, it's really one-dimensional lines, but we know that buildings aren't constructed like that. So the registrar's requirements regulations have some very useful diagrams in relation to working out what is and isn't part of common property versus private lot property, or between two different private lot properties, for example. Here's an example of the median when it deals with walls, windows, doors, and balustrades. And we've got a projection line through the middle to show which is on one side of private lot property, and on the other side, in this case, is common property. When it comes to water leaks, I think the first step most people see, or the most common water leak issue, apart from roofs, of course, or defective plumbing for storm water, are balconies. And they're the most probably common source of water leaks within owners' corporations that I see. And normally it's a balcony that's leaking, affecting the interior below. And most balconies these days are what's called an interior face boundary, which means that the boundary lies along the interior face of the floor. And any internal coverings like waterproof membranes, screed, tiles, etc., usually are part of the private lot property as opposed to the common property. So the structure of the balcony normally is the common property, depending on the plan of subdivision, of course. But if it's an interior face, normally it will be the tiles, waterproof membrane, and the screed will all be part of private lot property, which then means that if there's a defective waterproof membrane, usually it's the private lot owner that's going to be on the hook for the issue. And in relation to how do we work out that it's the waterproof membrane is part of private lot property? Well, there's this handy case in 2014 from VCAT called the Fisher case, which is really the test of confirming that in an internal face balcony, the tiles, waterproof membrane are not part of common property, but are rather part of an individual's private lot property. And that's really the main authority that confirms the difference of why balcony tiles and waterproof membranes are part of private lot responsibility because of this case. And this also applies in most cases, even if the plan was registered prior to 2011, when the registrar guidelines only came in at that point. So what if we find out that the balcony is leaking and it's a defective waterproof membrane? If a private lot's leaking, there's a statutory duty under Section 129 of the Owners Corporation Act, where lot owners are required to properly maintain their private lot in a good and serviceable repair. And in particular, the obligation is that they must maintain it so it does not adversely affect the outward appearance of the lot or the use or enjoyment of other lots or the common property. So there's no rule about whether or not, if your internal part of your lot, isn't painted, or you've got, carpet that's ripped up. That's irrelevant. The Owners Corporation Act doesn't care about that. But if, for example, there's a water ingress issue because of a defective waterproof membrane and it's causing water problems below or to common property, then the Owners Corporation Act kicks into gear, and that's when there's an ability for the Owners Corporation to take action if they need to. So what powers do an Owners Corporation have in relation to private lot defects that are affecting either the common property or private lot property? And we see a lot where there's a defective waterproof membrane, water's leaking through into the downstairs apartment, but it's also affecting the common property slab in between the two apartments. And that means that if that's not dealt with, there's also potential for concrete cancer or other issues that might affect the structural integrity of the building. So whilst the Owners Corporation can take a passive attitude about a matter, if it is going to affect common property, they really have an obligation to take some sort of action. And they can do that under Section 48 of the Owners Corporation Act. So that section basically says that, look, if the lot owner isn't complying with their obligation to maintain their private lot in accordance with, because it's affecting the outward appearance or outward state of repair of the lot, or the use and enjoyment of the lots or common property is adversely affected. So if there's water ingress, then the Owners Corporation can serve a notice on the lot owner. So that lot notice needs to say, hey, there's an issue, set out exactly what the issue is and set out precisely what it is the Owners Corporation says the lot owner needs to do. So for example, in the case of a water ingress issue, the lot owner below said, look, I think there's water leaking through the roof. In my view, it would be prudent for the Owners Corporation to send out a plumber or someone to work out what is the cause and issue of the water ingress. Now, they might prepare a report and find out that it's a defective waterproof membrane on, the apartment above. Whilst that's a private lot issue, it's really an issue that the Owners Corporation need to take ownership of and say, okay, well, look, that's an issue. We need to investigate and make sure it's not common property. It's not common property, but it might affect the structural slab. Therefore, we're going to do a 48 notice and require them to rectify in accordance with the report that's been obtained. If they don't rectify it within 28 days, and in most cases, almost impossible to rectify something within 28 days, the Owners Corporation is then permitted to carry out the works and then seek the amount as a debt from the lot owner. Now, the question is, well, how do you do that practically? If the waterproof membrane is defective, how does an Owners Corporation go in there? Do they, kick down the door? Do they pick the lock? What do they do? Well, the simple answer is they can't really do any of that. They have a right under Section 50 to authorise a person to enter a lot. But if really you need the consent of the lot owner, and if you don't, you serve a notice to say, hey, we want access in 7 days. And if they don't give access, well, then you can go off to VCAT and seek an order. The notice of entry that must be given has to be at least 7 days, unless it's an emergency. So an example of an emergency might be there's a burst pipe in the kitchen, the person's away, and it's flooding the place. In those situations, I've seen where the fire brigade have turned up, they've knocked down the door and gained entered, turned off the water. As an Owners Corporation, could you do that? Possibly, but the real problem you have as an Owners Corporation is you're always potentially faced with litigation or someone saying, well, firstly, the costs of doing that, but also if, something went missing or there was some further damage. In my experience, it's best to leave it to people like the fire brigade who would come in and deal with a water ingress issue like that if it was an emergency, or go off and seek an urgent order from VCAT. It will really limit the exposure of an Owners Corporation. And I've set out here what kind of emergencies would be appropriate that would mean that you could probably go in with very little notice if needed. Now, if there was an emergency and the only option is to break down the door, then arguably you could do that, but you need to be very careful. And I think I'd get legal advice before I took any drastic action like that to make sure it really was an emergency. And I've just put up a case of an example of what Section 51 does. The important thing to note that if the owner is not the occupier and it's actually subject to a lease, you also need to give appropriate notice under the Residential Tenancies Act, which can extend the 7-day period to 14 days or more. So what if the leaks are coming from common property? So if the experts determine that the leak is coming from common property into private lot property, what you do next is really depending on how old the building is. So if the building's more than 10 years old, then really, it's common property issue. The owner's corporation will need to rectify the issue and pay for any costs associated with the rectification. The question is, was there insufficient maintenance or was it original building defect? If it's an original building defect, the obligation on the owner's corporation may be reduced. And I'll talk about that in a bit more detail in a minute. And if the property is within 10 years, well, then there might be some ability to go after a builder or other party. And if it's less than 6 years, there's also plumbing insurance that might be applicable that a party can pursue if it's a plumbing issue. So as I said, if there's an emergency, there is the ability to carry out urgent repairs if needed. But as I said, get some legal advice before you kind of bust down someone's front door. So Section 46 of the Owners Corporation Act in Victoria requires an owners corporation to repair and maintain common property and any services or fixtures. So what that means is it's a positive obligation that you need to make sure that the common property is maintained well at all times. So if there's a defect or an issue that arises, then it's the owner's corporation's responsibility to take immediate action or action within a reasonable time. Unfortunately, what it also means, though, is that private lot owners aren't able to do work on common property if the owner's corporation refuses to do the work. And there's a specific provision now, I think it's 46A of the Act, which prohibits a lot owner from carrying out works to common property. So you get this position where, there might be a common property water leak, and as a lot owner, you've asked the owner's corporation and they ignore you because whatever reason they don't have a very good manager, probably not one of the people that are on this seminar, or that alternatively, it's too hard basket, or the committee don't like the person, or whatever the reason is. You can't then carry out the works yourself because there's a statutory prohibition to that. Your only option really is to go off to VCAT. So it's really important for owners corporations to understand that you've got a liability, you need to rectify that. And the sooner you rectify it, the less consequential loss there'll be. And what I mean by that is, if I can't occupy my property because of water ingress and I can't lease it out, then there's a good chance that the owner's corporation is going to be faced with a loss of rent claim. And that will just continue and continue until such time as the issue has been rectified. And Section 47 deals with repairing services where it benefits more than one lot. If it's just benefiting exclusively for the benefit of one lot, then that lot owner is responsible for the service. So Section 47A is the section I was referring to, where lot owners are prevented from repairing, altering, or maintaining the common property or services that generally service more than one lot, unless they're authorised by the owners corporation as their agent to do that. So you're going to be in breach of the Act if you kind of carry out self-help. Although, in some cases, a lot owner might go, well, I'm just going to do it because it's cost me $1,000 to fix the issue and it will solve my problem. But you've got to be careful because you will be technically in breach of the Act. It's also important to note that if the owner's corporation is going to carry out some major rectification work, we need to work out, well, is an ordinary resolution sufficient, or does the owner's corporation need a special resolution in order to carry out the works? And that will really be dictated by the nature of the works. Is it a significant alteration to common property? Is it just really repair and maintenance? Is it more than twice the annual fees? It might require a special resolution, but if it's, the annual fees are $100,000 a year and it's a $10,000 job and it's patching a roof or it's doing some roof plumbing, then it's not going to require a special resolution, and an ordinary resolution is going to be sufficient. So we've talked about the obligations under the Owners Corporation Act, but with water ingress issues, there's also obligations under the Water Act 1989, and we'll talk a little bit about those now. So in addition to having those obligations, so the Owners Corporation's obligations under 46 and 47 and a private lot owner's obligations under 129 of the Owners Corporations Act, there's a general obligation under the Water Act under Section 16 to deal with unreasonable flow of water. So what does that mean? So if there's a flow of water from one person's land to another, and it's not a reasonable flow, and the water causes injury or damage to property, or there's some other economic loss, the person who caused the flow is liable to pay damages to the other person. So what does that actually mean? So in the context of a defective waterproof balcony, where there's insufficient drainage or coverage of water, water rains comes down onto the balcony, seeps through the tiles into the floor, through the and you look up and the plaster's got a big hole in it because water's coming through the roof. That would be deemed an unreasonable flow of water, because it's not reasonable for water to flow through someone's roof, and there's been a failure effectively to properly divert the rainwater from the tiles into the stormwater drain through an effective waterproof membrane and drainage system. So in that case, the cause is the water ingress because of the defective waterproof membrane. That's got to be fixed. And then the loss or the damage that is caused through the Water Act that can be claimed is, the plaster that needs to be fixed. There might be mold remediation. The carpet might have been damaged. Other personal possessions or items might have been damaged in the water ingress. So if you're being affected by water ingress, it's important to properly document all the issues that are occurring, get an expert, but also take photographs and acknowledge, timelines and work out how much water is coming through, etc. The one thing that some people forget when it comes to those that are victims of water ingress is you've got a positive obligation to reduce or minimize your loss. So how do we do that? So if water's coming down in a steady stream, it's probably putting a bucket under there to catch the water rather than just letting it go all over the floor. If it's underneath an electrical appliance and the electrical appliance can be moved, we'll move the electrical appliance rather than just let it sit there. Now, of course, things will get damaged without you knowing. Things might have been damaged overnight, one night, for example, and you don't have an opportunity to minimize your damage. That's fine. But if you do have an ongoing leak that is there for a long time, it's really an obligation to reduce the scope of your damage. Otherwise, you won't be able to recover it all. So the other cause might be is when you negligently interfere with a flow of water. So for example, you might remove a stormwater pipe, or you might redirect it and it causes additional water flow into a particular area. That might be another reason why you get put on the hook. Or you just, you fail to connect your stormwater pipe to your drain. It's sitting there and it's just splashing about everywhere and causing unreasonable flow of water. That's another common problem. One thing to note is it's not just acts or things that have been done by you personally. You are liable if, for example, you had a builder and the builder constructed did some roof plumbing or, some plumbing works and failed to connect the pipes up properly. You will be liable in relation to that water ingress issue just the same. You might be able to pass on liability to, the contractor that you engage, but ultimately you're the one who's going to be responsible directly to the person who's being affected by the water ingress. If the water ingress has been caused by works that were constructed or done before you became the owner of the land. So what I mean by that is, the balcony problem is the classic example. There's a defective waterproof membrane, but the property is, maybe 5 or 6 years old, and putting aside any rights to go to the builder. If the waterproof membrane was never correctly installed, well, then they were works done before you became the owner, because the developer, finished the project with the builder, provided it to you, you bought it off the developer or potentially some other person, but the defective works were already defective when you got there. Then you're not going to be held responsible for issues that arise for that defective work from the period before you were told about the issue. So what that means is, if I'm suffering water ingress, I send an email up to you and say, hey, I think your balcony is leaking. To the extent that you don't take reasonable steps to stop the flow of water, you're going to be liable for any damage that occurs. But if the water's been running through for the last 3 years, then you're not going to be responsible for that component of the damage. Now, in most cases, the liability will almost be the same, because water might happen straight away. and there might be initial damage, and you haven't taken reasonable steps to fix it because you've waited too long to engage a contractor to fix it. But that's a provision that really deals with reducing your liability if it's really you've inherited the problem from someone else, but you'll still be responsible for the problem. So what's the effect of Section 16 of the Water Act? An owner's corporation will be liable to a lot owner for damage that is caused from an unreasonable flow of water from common property. So if the roof is common property and it's leaking, it's causing damage to a private lot, usually the private lot person owner will be able to recover costs and damage, etc., from the owner's corporation. And the owner of a lot will be liable for damage if it's the cause is from private lot property. So if it's private lot property versus private lot property, upstairs versus downstairs neighbour, then the upstairs person is usually going to be liable for any claim that the downstairs person has, and the owner's corporation is not going to be liable usually, except to the extent that the owner's corporation has contributed to the water ingress. And that's where it really becomes quite difficult when you're working out a water ingress problem, because sometimes it's very clear cut. It's a defective waterproof balcony. Other times it's some issue with the balcony. It's also an issue with the facade. It's an issue with the drainage system. There might be multiple issues that affect an owner's corporation, and it might be part common property, part private lot property. And that's really becomes quite tricky, working out who's liable. The main thing that parties really need to start working on is fixing the water ingress issue to stop any subsequent loss being claimed. Here's an example of a case from 2015 where there was an applicant, Ms. Connor, and his wife were tenants of a first floor apartment in an 8-story complex in Melbourne, and there was sewage dripping from the ceiling into the laundry. And then all of a sudden sewage was dripping into bedrooms. It was a nightmare. The plumber was called, and they found that there was a blockage in the sewage stacks located in the ground floor car park. And there was a build-up of material of a whole range of things which had been flushed down toilets. And the issues really was the sewage stack common property and was it an obligation of the owner's corporation to rectify the issue and all the subsequent losses, because but it wasn't really whilst it was the owner's corporation sewer stack, really the cause of the issue were blockages by individual lot owners. And was there a claim under the Water Act because it was sewage and not water? The tribunal said, look, it's not an issue about whether or not the OC failed to maintain the sewer stack, but what was the cause of the blockage? And the blockage was effectively people flushing stuff down. And it wasn't required. It was said that, look, the owner's corporation is not required to monitor the maintenance and state of repair of the common property. And the OC shouldn't have really been aware that there was a blockage if the sewer stacks were appropriately, within, Australian standards, that are the right size, etc. Just happened that certain lot owners were heavy on throwing stuff down the toilet. And therefore, the OC hadn't breached its general obligation to repair and maintain the sewer stacks under the Owners Corporation Act. And because the OC didn't cause the flow of sewage from the sewer stack into the apartment, they weren't liable under the Water Act, because as we went back, under the Water Act, you're only liable if you've caused the unreasonable flow of water. And water in the context of the Water Act includes sewage and stormwater and everything that goes through a drainage. So it was kind of an interesting case where it was common property, but it wasn't actually the result of the owner's corporation. The owner's corporation was on the hook. Now, in that type of case, you would think that there's probably an insurer that could get involved and arguably might be covered by insurance. So that's something to consider. Let's skip through a case. There's another case that was in 2018, which talked about air conditioning servicing lots of a building. And the question was whether or not there was a defective fan coil in one of the units, and it was only servicing one lot. And the question was the unit that's only servicing one lot really a service for that one lot, or was it part of the whole system? and it was found that it was really part of the one system, and being part of the one system meant that it was the responsibility was the owner's corporation. So what we can find is that different parts of services in a building that might cause damage, like water ingress issues, air conditioning, sewer drainage, etc., can sometimes be common property, but it can also be private lot property. So it can be quite tricky, and normally you won't be able to find this out without further investigation by the experts. So let's talk about general building defects, and what do we do if the building is less than 10 years old? Can we go after a builder? Can we go after someone else? So really the issue is identifying the issues of the property, work out is it common property or private lot property or a mixture of two. The reason for that is we want to know who's making the claim. Is it the owner's corporation or is it private lot owners? Because the owner's corporation can't necessarily make a claim on behalf of private lot owners unless they acquire the rights with the approval of that private lot owner. So under Victoria, it's good that we have what's called statutory warranties. So what that means is there's a list of warranties that are guarantees by a builder that are implied in every building contract. Now, the benefit of those warranties lasts not just the person who entered into the building contract, usually the developer, but are passed on to subsequent owners of that building or that property for the 10-year period. And if it's in relation to cladding, that's extended by a few extra years. So ultimately, what that means is an owner's corporation has the ability to rely on these statutory warranties when it comes to common property. And some of those are the work was carried out in a proper and workmanlike manner in accordance with the plan and the specifications, that all materials were good and suitable for the purpose that they were being used, and those materials were new. That generally the work is done in accordance with all requirements, the regulations, the Building Act, and there's reasonable care and skill associated with the construction. So that's really, there's a whole range of those warranties that owners corporations can rely on if there's a defect. The question will become, is it a defect because of poor construction originally or poor design? Or is it a defect that's arisen because the owner's corporation has failed to maintain the particular thing that we're talking about that is now defective? So an example of that might be the facade. The facade is now leaking. Is that because of poor design, poor construction, or the fact that they failed to properly paint it and treat it every X number of years as recommended by the manufacturer? So that's where there'll be disputes between builders and owners corporations about the nature of whether something's a building defect or really a failure of maintenance by the OC. So once we've worked out what the issue is, we need to find out, well, who's the builder? And sometimes that's really easy. The builder it's clear. Sometimes it's not so easy because building companies create new companies. Most of our larger builders in Victoria, the building company they currently use is not the building company they used 5 years ago, 10 years ago, 15 years ago, etc. They kind of recycle new companies. So you need to figure it out. And the problem is you can go to the builder and ask, and a lot of the time they won't tell you. There'll be a particular company, but they'll use their general name, not their specific entity name. So it can be quite tricky. And when will it be? So if we've got building work, can we actually sue? Under the domestic building statutory warranties, it's only for residential apartments or buildings that are mainly residential. If it's purely commercial, then the statutory warranties won't apply to commercial premises. Now, if there's only one or two commercial premises in the building, it's still probably going to be okay, but you just need to be mindful of that. So if there's a breach of the statutory warranty or there's a failure to maintain a quality of the building work as required, then action might be able to be taken. It's really important to note that there's a limitation on when you can issue proceedings, and that's 10 years after the relevant occupancy permit's been issued. And a lot of the time with large developments, there are multiple occupancy permits. So it's really talking about the first one that's been issued related to the issue of work that's defective. If there's plumbing work, then you can go after a plumber's insurance, but you've got to do that within 6 years. It's really important to get expert evidence, and we try and get clients to get expert evidence up front, even before we issue proceedings at VCAT, because you want to know exactly what is the issue, what's the recommended scope of rectification, so you can go to the builder and say, hey, this is a defect, and this is how our expert says it needs to be rectified. Because you'll find that some builders will say, okay, well, we acknowledge that there's a defect, and we've gone out there today with our silicon gun and we've fixed the issue. And of course, your expert will say a silicon gun is not a rectification of most issues. You actually need to do X, Y, Z. And without knowing what is the appropriate thing to do, it's really hard for the owner's corporation to be satisfied that the issue has been rectified correctly. And that's where an expert really is critical. So we've got an expert report, we've gone to the builder, and the builder says, get stuffed. What do we do next? We go to the Domestic Building Dispute Resolution Victoria and lodge a dispute, and they will organise what's called a conciliation, which is like a mediation, a roundtable discussion with the builder if they are willing to turn up, a facilitator from the organisation, and someone from the OC and their lawyer if they've got one. And that's really a process to try and work out if the matter can be resolved, if the builder's going to accept liability, and what's an action plan to rectify. If there's large-scale issues, usually this process will be a complete waste of time. Particularly for owners' corporations. If it's complicated or there's too many issues or it's too controversial, you won't get a settlement. If it's a small issue, then you're more likely to. That process can take a while. So it's important to start this process well before the 10-year period is up. If that doesn't work, you get what's called a certificate of conciliation, which then allows you to go off to VCAT or alternatively potentially the county court, where we issue an application and points of claim setting out what it is that you're claiming is defective, backed up by an expert report. And then many months later, you'll get what's called a directions hearing, where that will set out orders for the future conduct of the matter, where the builder can put in points of defence, their own expert reports, and then ultimately there'll be another mediation or compulsory conference, which is a roundtable conference to try and settle the matter. If it doesn't settle, then you'll get a hearing. And at the moment at VCAT, they're not even listing hearings, likely 2 years plus away. It's really important that owners' corporations get the expert evidence before, because if they don't before they issue, they're going to extend the time frame by at least another 2 to 3 months, if not longer, by doing it. So the quicker you get it done, the quicker you can give to the builder, the less time that they have to say, well, they don't really understand what the issue is. So to the extent that any part of a claim relates to private lot property, if the owner's corporation is to pursue any of those claims, they really need to join the relevant lot owner. And if you're a private lot owner, you really need to get you can rely on the owner's corporation, but ultimately you need to get your own advice as to what the issue is, rectify if it's appropriate. The other thing to note is that if you want to issue proceedings against the builder for defective building works, you'll need a special resolution if it's worth more than $100,000. So you'll need to do a formal ballot or general meeting. So domestic building insurance, which is known as home warranty insurance, it's only if the building is 3 stories or less and the construction contract's more than $16,000. It really only applies if the builder has gone insolvent, dies, disappears, etc. If they're still around, you've got no ability to go after that. There's also a limitation period of 6 years for structural issues and 2 years for non-structural issues. So the extent that you can use domestic building insurance as an owner's corporation is usually quite minimal, because most of the time these issues come up much longer after 6 years. All right, so I think that's it for me. Nikki, I think probably ready for questions.
Okay, thank you so much, Phillip. There were obviously lots of content to cover in there. We did have quite a few questions come in previously, and then we've had a few more come in through chat. And we'll just start with a question. Once an owner's corporation has repaired a leak coming from common property flowing into private property under the Water Act, the OC are aware that the costs for any private damages, private apartment damaged plasterboards and carpets, should be paid by the entity who owns the property where the water originated, as the lot owner affected by the leak forms part of the OC and wholly benefits from the repairs. Is the OC able to apply the benefits principle? All parties wish to keep insurance out of the picture.
Yeah, so if it's private lot defects, and in order for the owners corporation to take action, they need to do the Section 48 notice. If they do the Section 48 notice and it's not complied with, then they can carry out the works subject to get consent of getting access and then charge it back directly on the private lot owner. Alternatively, if it's common property work, then they can try and apply the benefit principle if it only applies to one or more of the lots, but not all of the lots. And that's under Section, I think it's 49 of the Act, which says that they can apply the benefit principle for those type of works, or alternatively, just the general repairs and maintenance obligation, the ability to pass on the benefit principle. The key thing here is, though, is if I'm apartment on the top and there's apartment on the bottom, I can't I can't do anything to the bottom lot owner other than lot liability. So I can only go the top part to the extent that it's liable. But if it's, for example, a roofing issue and it falls down to the apartment below, well, the roof is really benefits all of the owner's corporation because it part of the structure, it's part of the benefit. You won't necessarily be able to apply the benefit principle in that situation. So you've got to look at each case as to whether or not you can or can't apply the benefit principle.
Okay, thank you. And we had a question: if a water leak from one unit causes water to flow down through the floor into the ceiling of the downstairs unit, does the owner's corporation get involved in arranging the repair, or is that up to that lot owner?
Well, I think if we know that it's definitely a defective waterproof membrane from the private lot, I don't think the owner's corporation needs to get involved unless there's going to be a potential consequence on the structural slab in between. In most cases, though, if it's not, if the owner's corporation is not, or the parties aren't sure about the actual cause of the leak, I think it's prudent for owners corporations to spend the money to get the initial expert's advice to make sure that it's not common property. Because the worst thing to do is the owners corporation says, it's not our problem, it's private lot property. 2 years down the track, the person hasn't rented out their property and there's a massive loss of rent claim. And then we find out that, in fact, it was common property. Well, the owners corporation would have saved themselves a lot of money had they made that investigation and spent $2,000 to get a plumber out there to have a look at it. So I think it's always prudent for an owners corporation to make that initial investigation, although technically they might not need to if it's not common property.
Okay, so if you're that owner of the unit downstairs and you see that leak, the first port of call should be to the owners corporation or the strata manager and advise them that that's occurring.
Yeah, I think that's right. But if it's definitely private lot property, then the manager really need not get involved if it's definitely an issue with private lot property.
Okay, thank you. Our builder recently went into administration. We don't have any domestic building insurance as we're only 7 stories. Are there any other parties we can pursue or insurance we can claim on?
Well, it depends on what the nature of the issue is. If it's, for example, a defective, there was what's the cause of the issue? Is it just defective installation? Is it defective design? Because the defective design, maybe there's an argument that the building survey shouldn't have signed off on it. Building surveys have very limited inspection obligations, but sometimes it's possible to go after a building surveyor. Sometimes it's also possible to go after an architect or alternatively the original installer. It makes it much harder to go after these type of people, though. But you need to look at it depending on the situation and what expert evidence you've got.
Thank you. Another question, it was to do with building insurance. So our building insurance has a $10,000 excess for water damage. If multiple units are damaged, how do you divide the payment of the excess?
Yeah, so under the Owners Corporation Act from 2021, there was a change to how excess can be applied. The excess can only be applied if effectively the cause of the water ingress was attributed to the negligence of the person. For example, they left their taps on, they failed to maintain something. Otherwise, if it benefits multiple people, then the excess probably needs to be shared according to liability. But there's a specific section of the Act that talks about the different circumstances. So that's probably what I refer people to.
Okay, thank you. We've just had a question come through recently saying, can a defect be measured against current building standards versus the standards at the time of construction?
No, generally, look, the obligation for a builder is to build it according to the regulations and at the time. The building won't normally be subject to new regulations unless there is a substantial renovation. So you can't hold someone to a higher burden. With that said, cladding is probably a slightly different issue. With combustible cladding, but, you know, arguably combustible cladding was never appropriate, even though it was used widely. But, you know, there are specific provisions about combustible cladding and dealing with that.
While you were speaking about the Section 51 notice of entry, we just had a question come up in chat at that point saying what liability exists while you're awaiting VCAT and who is liable?
Well, ultimately, it depends on if, for example, you're trying to get access to someone's lot because you need to do repairs to common property, well, then you would argue the failure to allow entry would be on, you know, for that period would be on the person preventing the entry. So you'd probably seek orders that, you know, if there's loss of rent and it's taking you an extra month to get in to fix the issue, you would try and palm that on to the lot owner who refused entry. If it's just generally the private lot person, well, you're probably going to go after the private lot person anyway, because they're the ones who are causing the damage.
If the owners corporation has agreed to the liability, is there a time frame that the work needs to be completed?
Look, committees have an obligation to act in the best interests of the owners corporation in good faith, which means that they should act reasonably in doing things. So, you know, the reality is committees are volunteers. You know, everyone has lives other than being on a committee, although some people probably think that their lives on a committee overbear their normal life. You need to take prudent, reasonable steps. So, you know, if there's a water leak, you know, you need to start making inquiries about a plumber or getting someone out there within a week or so. If you just leave it for months and months, you're not really fulfilling your obligation.
And I thought this one was interesting. What if the water ingress is from outside of the property itself? In this case, it was a council laneway, but it's coming from outside the property.
Yeah, so I've had situations where water's coming in from a third party. The applicant, then it's really whoever's losing out or has got the loss needs to go after the person who's caused the unreasonable flow of water. So if that's the next door neighbour, then it's a Water Act claim against the next door neighbour. So I've seen situations where owners corporations have sued other owners corporations in relation to unreasonable flow, you know, because they've built up the land or they've failed to put you know, appropriate drainage, etc.
And who is responsible for replacement of damaged carpet within private lot if the leak is from a common roof? The owner refused to claim against the contents insurance. And I must admit, we get asked a lot of questions about carpet and damaged carpet and who's responsible for that.
Yeah, well, I mean, that's what insurance is for. But the problem is that lots of people are reluctant to claim on their insurance because of the excess and also because of insurance premiums increasing thereafter. Ultimately, it will depend on the facts, but if the water is as a result of a defect in private lot property or common property, it's going to be the person who's caused the defect and the unreasonable flow of water that's going to be responsible for repairing the carpet. It's not really up to the individual to claim on their own insurance, although, you know, if there's a situation where the water leak has stopped, then they're really got an obligation to rectify their carpet and then sue for the balance rather than just leaving it untenanted for 6 months waiting for someone to pay for it.
Okay. Can a renter seek compensation from the owners corporation for loss of amenity, a use of a bedroom due to a water leak, or must they seek compensation from the lot owner who they pay the rent to?
Yeah, well, usually it would be the lot owner claiming from the landlord for the landlord, and then the landlord claiming from the OC is usually what would happen, because that's the relationship between the two. Although occupiers can make claims directly, but normally you would see it go up the chain.
Okay. And what about cold water pipes through a building? If a pipe bursts in a wall in one unit, is it the OC responsibility for repair?
Yeah, that's why I raised that air conditioning case, because it really depends on if it's all part of the one system. It's part of the one system that's really common property. It doesn't matter that the pipe's within a private lot's pipe, but if it's, you know, the private lot's tap that's, you know, that's broken, well, that might be a different story.
And for defective works on common property, what contract can you rely on to pursue the builder or the developer?
Yeah, so most of the time you won't have the contract, so you have to rely purely on the statutory warranties, because there's no contractual relationship between the OC and the builder. So your rights as an OC really only stem from the statutory warranties. you can't rely on specific clauses in the contract usually. And normally you won't even get a copy of the contract because no one will give it to you.
Is it possible to determine a defect in construction older than 20 years?
It's always possible to work out an original construction defect usually. The question is, what's the impact of that? If it's more than 10 years old, unless it's, cladding issue, doesn't matter because you can't go after the builder anyway. So it's whether it's an original construction defect or not, might have some relevance to the Water Act and whether or not someone's liable. But, if it's an original construction defect after 20 years and you're only knowing about it now, it's probably not really that relevant.
Well, I think that's just about covered all of the questions that we had come in. Thank you very much for that. We peppered you with questions right at the end there. Did you have anything, Phillip, you'd like to share with the audience before we finish the session?
No, look, I suppose it's just important to get expert evidence and legal advice as to the boundaries. Quite often, the biggest bone of contention is when owners' corporations think that it's not common property, but in fact it really is, or alternatively, personalities get involved and they don't want to step in and rectify something. A lot of the time, the best answer is to rectify things early because that's going to prevent a bigger claim from happening.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.